I guess. I think the Solicitor General came pretty darn close to saying it today. Berne does require that you restore the copyrights from foreign countries when they, of foreign authors that were published abroad, when those works are still protected in the countries of origin. People can argue about reliance parties. People can argue about what Article 18.3 says countries can or cannot do. But let's start with the basic proposition that most people who want to use the works that were in the public domain but were then given copyright under Section 104A of Title 17 are not reliance parties. And you look at Article 18, I don't think it's a plausible reading that says a member of Berne can avoid restoring the copyrights in those works with respect to just anyone who comes along later and wants to use them. Article 18.3 gives countries some latitude in terms of what they can do with respect to the implementation of Article 18, and the treatises suggest that that means that, particularly with respect to reliance parties, you may have some temporary measures that give them a break, give them an opportunity to sell off existing stock, to continue to exploit it under certain circumstances, but that time must come to an end. So when you look at it in that context, it makes sense. It still may not feel very good to the plaintiffs, and I certainly understand that. One can still argue whether it's a good policy or a bad policy, and I can understand that. But the other thing I think that's important to think about when you think about the argument today and what this case about is that we're not writing on a blank slate. We've got the Elder decision from just, 10 years ago? 8 years ago? Okay. And the court said a lot in the Elder decision that is either going to guide what the court says in a few months when it makes a decision in this case, or the court's going to have to repudiate it, which is probably unlikely. And one of the things the court said in Elder, and I am paraphrasing, is that the Copyright Clause gives Congress the power to write really bad laws. That's what Congress did when it extended copyright term in 1998. That's my view. Personal view, absolutely. Is it the view of the Copyright Office? Probably not, although maybe. Is it the view of the United States? Absolutely not. But if Congress could grant another 20 terms, another 20 years of protection to works that were already protected, I don't think that what Congress did here is any less justifiable. In fact, I think it's probably more justifiable. And the reason I think it's more justifiable is that Congress did that in order to enter an international system which is increasingly important. Let's take the motion picture industry. Most motion pictures don't even make a profit until foreign sales come into the picture. The international market is very, very important for an increasing number of copyrighted works, and our copyright industries are one of our chief export industries in the United States. So it's very important for the economy. And I think Congress is entitled to take that into account when it's legislating in the field of copyright. That's enough for now.
Okay.
Can I clarify a couple things?